Good evening, everyone. Welcome. My name is Berenice Buta. I'm a researcher at the Asser Institute, and I wish to welcome you all to this Supranational Criminal Law lecture. So this event is part of a lecture series which has been running since 2003, and which is organized by the Asser Institute in cooperation with the Coalition for the ICC and with the Grotius Centre for International Legal Studies of the Leiden University. Tonight we are very happy to welcome Dr. Res Schresch. Res graduated in 2009 from the Faculty of Law of the University of Zurich in Switzerland, after which he started a PhD at the University of Amsterdam in 2011 under the supervision of Professor Harmen van der Bilt. After 1 year at the UVA, Res returned to Switzerland and worked in different positions at the University of Zurich, while at the same time continuing with his PhD in parallel. And in April this year, he defended his PhD at the University of Amsterdam. The title of this dissertation is "The International Criminal Court at the Mercy of Powerful States: How the Rome Statute Promotes Legal Neo-Colonialism." And as you can see from the title of this lecture, today he's going to tell us a bit more about his dissertation. Res, thank you very much again for being with us, and please have the floor.
Good evening, everyone. First of all, thank you for having me. Especially I would like to thank also Dr. Christoph Paulussen, who is not here today, but who organized me for having here, and also thank you Berenice Buta and Mrs. Marlos van Hooijdonk for inviting me and organizing this event. I'm very grateful for this opportunity. So before I will deal with the content of my dissertation, I briefly explain how I became fascinated of this topic. As you all know, the ICC was initially welcomed with great enthusiasm by the international community, which hailed it as a major step in fighting impunity and towards legal accountability of individual perpetrators of most serious crimes worldwide. However, a few years and a number of investigations into African situations and cases later, initial enthusiasm has waned, and African constituencies in particular started raising serious misgivings about the court's selections of situations and cases, including allegations of neo-colonialism. Having seen these allegations, I asked myself how an institution which is designed to bring to justice perpetrators of most abhorrent crime can be seen as a tool of oppression in a colonial sense. Having an education in a Western legal system, moreover in neutral Switzerland, I obviously do not have the same emotional or practical connection to the topic of colonialism as people who suffered or still suffer from this concept of control. In this sense, the present dissertation is not written from an African perspective, but from a Western point of view with a focus on Africa. At the same time, this emotional and practical distance, so I hope at least, might have contributed to what I would describe as a sui generis perspective to the concept of neo-colonialism in the context of the ICC. So after this brief introduction, I will now begin with the conclusions of my dissertation. In this context, it is important to note that it was not clear at the beginning of my dissertation which provisions of the Rome Statute are going to be assessed, as I had no clear picture what the concept of neo-colonialism, which is traditionally understood in economic or political terms, would look like in the context of the ICC. However, I will come back with a more detailed explanation why other provisions than those assessed were not included later in this presentation. As you can see on the slide, I have particularly focused on Articles 13b, 16 and 98, paragraph 2 Rome Statute. The first two provisions deal with the referral and deferral power of the Security Council, while under the latter provision, United States bilateral non-surrender agreements were analyzed. In particular, 5 different situations, of which I labeled 2 a case of legal neo-colonialism, were assessed. First, we have de facto immunity of the Permanent Five of the Security Council and friendly states in the case of an Article 13b referral, and de jure immunity provided by the Security Council from ICC prosecution under Article 16. Other situations, such as de jure immunity under Article 13b, the non-application of Article 16, which was particularly discussed in relation to the situations in Kenya and Sudan, and the United States bilateral non-surrender agreements may not be labeled a case of legal neo-colonialism in the sense of the present study. So how did I get to these conclusions? As the title of the dissertation suggests, it is a blend of historical and legal themes. Thus, in the first step, the historical dimension of the notions of colonialism and neo-colonialism was elaborated. This part was complemented through an analysis of how law was used as a tool by European states during colonialism in order to obtain a legal understanding. As I have said before, this was necessary since the traditional understanding of neo-colonialism is more of an economic or political as opposed to legal concept. The received understanding of legal neo-colonialism was then transmitted to the field of international criminal law. First, we have classical colonialism. This concept of domination is characterized through the acquisition of territory, formal or direct control by the colonizers, and the fact that colonies were attributed to the sovereign realm of the colonizing state. Neo-colonialism, on the other hand, was seen as the informal continuation of colonial dependencies and is based on the understanding that former colonial powers kept their former possessions under political and economic control after obtaining independence. This they did through structures introduced during classical colonialism. Both concepts required as an internal condition clients on the part of the colonized people, which assisted in maintaining the system of subordination. I will in brief return to this phenomenon, which I have described by means of the patron-client concept. The section on legal colonialism analyzed the legal structures introduced by the French and British in their African colonies. The imposition of law was notably based on the belief of cultural superiority by the dominant actor. Accordingly, legal and political structures were introduced which formalized the exercise of colonialism by the different European powers and served the promotion of inequalities. At the same time, these structures provided the foundation for neo-colonial relationships between European powers and their former possession in the post-colonial era. In dealing with the notion of neo-colonialism, the present study applied the typology of structural and relational power, a conception that was introduced by Susan Strange to describe the dynamics of the world economic market. While relational power is exercised between two or more unequal actors in non-permanent relationships, structural power describes the notion of power in systemic terms. This means the asymmetric relationship between a superior and an inferior state is predefined by external conditions such as economic, social, or legal forces. This form of power is permanent in nature. The patron-client concept, which I have addressed beforehand, has not only been an important element in colonial and neo-colonial relationships, but at the same time is a feature of present-day interstate relationships. The conditions of the patron-client relationship are determined by the relation and power of the actors involved. Essentially, and as will be shown in relation to the field of international criminal law, patron-client relations serve to extend structural power of the patron to the client. As such, it is always those who remain outside of this dyad that suffer the negative effects of neocolonialism. The adopted understanding of neocolonialism thus implies that relationships between states of unequal power and capabilities are based on structural conditions that favor the interests of the dominant actor in these relationships. In legal terms, neocolonialism thus becomes manifest in case that 1. Law is imposed without the approval of the societies concerned, and 2. The imposed law is selective and enforced in the interests of the colonial or neocolonial power. Following the elaboration of a historical framework of neocolonialism, it was first assessed whether an imposition of Western laws and values can also be claimed in the field of international criminal law with regard to the system of core crimes. While the historical origins of the international core crimes unsurprisingly revealed a Western background, with the post-World War II military tribunals taken as a starting point, international criminal law has undergone an impressive transition up to this day. Most notable developments are the adoption of the Nuremberg Principles as well as a number of conventions dealing with these crimes. In addition, the rise of the principle of universal jurisdiction and the establishment of ad hoc and hybrid international criminal tribunals are clear indicators that international core crimes have transcended their Western heritage and acquired a transcultural underpinning. Despite strong criticism of the ICC and the principle of universal jurisdiction, African states have themselves also strongly committed to these values by accepting them as generally applicable. While there are a number of noteworthy developments in support of these conclusions, which you can see on the slide, at least some of them, at this point I will only briefly explain the methodology that was adopted to prove the African states' acceptance of the system of core crimes. The assessment of the regime of core crimes is based on the understanding that those formerly Western values have acquired a transcultural underpinning over the past decades. Reference was in particular made to Emmanuel Chouanet's reappropriation of values approach. Chouanet has argued that it is possible to overcome the hegemony of a majority culture through the technique of ex post adoption, or as she calls it, reappropriation of values. In the context of the negotiations of the ICC, in which some 160 states and numerous international and non-governmental organizations have participated, this holds true in particular for the crimes of genocide, war crimes, and crimes against humanity, whose inclusion into the Rome Statute was largely undisputed during the negotiations. The preamble of the Rome Statute accordingly describes it as a delicate mosaic in which all peoples are united by common bonds, their cultures pieced together in a shared heritage. While this conclusion indicates that the system of core crimes, as opposed to colonial laws, has acquired a transcultural underpinning over time, it remains to assess in which situations these core crimes may legitimately be extended to states that have not consented to the Rome Statute. The ICC, as you know, is competent to exercise jurisdiction when a crime was committed on the territory of a state party or when the accused is a national of such a state. In the context of Article 12.2a Rome Statute, the court may thus exercise jurisdiction against nationals of non-party states who commit crimes on the territory of a state party. Although this provision is contested by the United States, there is no general rule in international law that prohibits states from transferring their jurisdictional power to the ICC in such cases. Where the Security Council issues an Article 13b referral, the court may also exercise jurisdiction in case a non-party national commits a crime on the territory of a non-party state. The extension of the statute to third states under Article 13b results from the structure of the United Nations, which provides in Article 25 that, I quote, "The members of the United Nations agree to accept and carry out the decisions of the Security Council in accordance with the Charter." End of quote. In regard to both provisions, the extension of universal core crimes to non-party states is therefore justified by reference to general principles of international law. However, as will be discussed later on, it is only with regard to Article 13b that the legal structure itself contains an asymmetry. So, having concluded that the Rome Statute can be justifiably extended to non-party states, the question arises whether this also implies that allegations of neo-colonialism are not applicable to the field of international criminal law. In my opinion, this is not the case. This is because the generality of norms does not prevent that a universal law internalizes structural conditions that are to the favor of powerful actors, and that on this basis the law is applied unevenly against its subjects. In this case, the result is the same as in the case of selective norms, namely that the subjects are treated differently on the basis of legal processes. A consequence of this same effects approach is that the technical categorizations of norms as general or universal does not preclude that the elaborated understanding of legal neocolonialism can be applied to the field of international criminal law and the ICC in particular. Here we come to the second prong of my definition of legal neocolonialism, namely the issue of asymmetry. In particular, the involvement of the Security Council within the system of the court, through reference to the concept of structural power, turned out to be a crucial element in the understanding of legal neocolonialism in relation to the ICC. With the creation of the Permanent Five of the Security Council after World War II, the Allied powers have established a legal framework which internalizes their preferences in the long run. The structural dimension of the system of the Permanent Five is thus comparable to colonial and neo-colonial relationships in that it consolidates the status quo of a few powerful states vis-à-vis other non-powerful states. The structural power of these states is characterized by the fact that their power does not, in the first place, correspond to the balance of power these days. Rather, it transcends the historical and temporal context on whose basis it was established, the Second World War. Moreover, The competence of the Council under Chapter 7 is such that it may intervene in Chapter 7 situations worldwide and is not bound by geographical constraints. The Chapter 7 structures established after the Second World War thus differ from pure relational aspects of power between states in that they are permanent and not subject to constant change. Accordingly, the structural power of the permanent five exists independently from external factors. As opposed to the Security Council, the Office of the Prosecutor does not exercise structural power, in my view. At this point, I will briefly outline why the non-selection of situations by the Office of the Prosecutor does not represent a case of legal neocolonialism in the sense of the present study. As you know, there are three different ways how situations can be brought to the ICC: a state party referral, a Security Council referral, or on the initiative of the prosecutor, which is also known as proprio motu powers. In all three situations, the prosecutor has to evaluate, provided that the admissibility criteria are fulfilled, whether there is a reasonable basis to commence or proceed with an investigation. Although the Rome Statute provides little guidance what reasonable basis essentially means, focus on the concept of gravity within the admissibility test suggests that the situation selection is also based on the gravity of crimes within the situation assessed. This is confirmed by the OTP's policy paper on preliminary examinations. According to these guidelines, the prosecutor must consider gravity of potential cases that would likely arise from an investigation of a situation. In its recent practice, the OTP has resorted to so-called relative situational gravity, which means that investigations are only opened when a situation is grave enough relative to other situations. In dealing with situation selection by the OTP, however, it is important to note that the prosecutor of the ICC, despite some legal criteria, has wide discretion in this regard, which is necessary, among others, in terms of resource management. Nevertheless, it remains a basic requirement that also a decision not to investigate must be justified on the basis of legal criteria. In further consequence, the OTP does not exercise structural power in the sense of the present study when it comes to the selection of situations, in my view. To briefly summarize what has been concluded so far, having determined that the universal character of international core crimes legitimates the ICC to overrule the sovereignty of non-party states in specific situations, we saw that the non-extension of these universal values is illegitimate only in circumstances where it is linked to the exercise of structural power. In this sense, legal neocolonialism in the field of international criminal law is defined in negative terms, in that the exercise of structural power defeats the principle that perpetrators of international crimes are held accountable. We now turn to the specific conclusions in regard to the Security Council referral power under Article 13b. According to this provision, the ICC may exercise jurisdiction where a situation is referred to the prosecutor by the Security Council acting under Chapter 7 of the United Nations Charter. In regard to this provision, I have assessed two types of immunity, de jure and de facto, of which I will only label de facto immunity of the permanent five and friendly states a case of neocolonialism. I will explain the concept of de facto immunity first. As we saw, Article 13b provides the Security Council with the power to extend the applicability of the statute to nationals of non-party states, even in case the crime was committed on the territory of a non-party state. At the same time, the structural conditions inherent to the system of the United Nations Charter, providing for veto power of the Permanent Five, de facto rules out that a referral is issued with regard to one of the Permanent Five states which are not party to the Rome Statute, notably Russia, China, or the United States. In other words, the historical privilege these states possess within the world community, combined with their power as a requesting source within the system of the ICC, confers on them a status which is above the law. What is more, the structural power of these states in the context of Article 13b can be extended to friendly client states which are not party to the Rome Statute. Recent examples of such patronal protection in the context of a looming referral to the ICC were Syria, Israel, and North Korea. However, while the Permanent Five are protected permanently from being referred to the ICC under Article 13b, the extension of the Rome Statute to client states is only opposed by one of the Permanent Five as long as the benefits of protecting nationals of client states trump the negative consequences of a non-referral. De facto immunity of client states which are not party to the Rome Statute therefore only exists on an ad hoc basis. As a consequence, Article 13b is only invoked against nationals of non-party states which neither form part of the Permanent Five nor are protected by one of these states on the basis of patron-client relationships. With the implementation of such de facto immunity, Article 13b fosters an asymmetry in the enforcement regime of the ICC. This is because some non-party states are treated differently than others within the system of this provision. The fact that the unequal treatment between different non-party states is based on immutable structural conditions within the system of the United Nations Charter and the Rome Statute respectively, and not on legal considerations, makes the underlying differentiation in treatment unjustified in the sense of the present study. In this sense, Article 13b de facto fosters a two-class enforcement system which promotes legal neo-colonialism through the reproduction of long-standing traditional inequalities based on structural conditions. We next turn to the concept of the Uri Immunity under Article 13b. As you know, the Security Council has used its referral powers twice so far, in regard to the situation in Darfur, Sudan, and in relation to the situation in Libya. In those resolutions, the Security Council has exempted nationals or personnel from a contributing non-party state outside Sudan or Libya from the court's jurisdiction. With this immunity clause, which you can see on the slide, notably in the context of the conflict of Libya, the Security Council aimed at the protection of Western countries that took part in this conflict. However, by analyzing the historical, literal, and contextual scope of Article 13b, it becomes clear that the provision does not allow the Security Council to limit the court's jurisdiction in personal terms. This is because the Council may only refer entire situations to the ICC. Accordingly, the Council cannot establish permanent immunity for a defined category of nationals by means of a referral. In further consequence, Article 13b does not empower the Security Council to establish the Uri immunity for their own nationals or nationals of friendly client states from the court's jurisdiction. The provision does therefore not foster the establishment of inequalities which are related to the exercise of structural power by the Security Council. This holds true even in the case the Court considers the excessive ratione personae interpretation of the Security Council a lawful limitation of its own powers. This is because the misinterpretation of a provision by the Rome Statute by the OTP cannot be attributed to the structural power of the Council. Next, I will explain how I came to the conclusions in regard to Article 16 Rome Statute. Under this provision, the Security Council is allowed to defer ICC investigations or prosecutions for a period of 12 months, provided that it has adopted a resolution under Chapter 7 of the United Nations Charter to that effect. That request may be renewed under the same conditions. Article 16 provides a different approach than Article 13b in two respects. On the one hand, Article 16 is designed to prevent or suspend ICC investigations or prosecutions and therewith allows the Council to temporarily limit the Court's jurisdiction in personal terms. In other words, an Article 16 deferral defeats the competence of the Court to exercise jurisdiction over a situation or case. However, as we saw, the Security Council is only allowed to act under this provision when it is acting under Chapter 7 of the Charter. There are two particular scenarios that were addressed. One dealing with the situation where the Security Council preemptively invoked Article 16 to prevent the ICC from commencing investigations or prosecutions, the other concerned with the non-application of Article 16 in the situations in Kenya and Sudan. Turning to the first scenario, the question arises whether the exercise of Article 16 can be subsumed under a previously elaborated framework of legal neo-colonialism. Article 16 principally allows the Council to exercise structural power and determine in which situations the ICC is temporarily prohibited from exercising jurisdiction. More specifically, the structural power element consists of the fact that the ICC, lacking power to review Chapter 7 determinations in substance, is also bound to deferral resolutions as long as they are in conformity with the Rome Statute. This holds true even where the Security Council exercises its deferral power on the basis of ill-defined or hypothetical Chapter 7 determinations only. This obviously adds a structural dimension to the exercise of Article 16, because the Council can steer the exercise of ICC jurisdiction in the absence of a threat to the international peace and security. An example where the Security Council only relied on a hypothetical threat to the peace were the Security Council resolutions 1422 and 1487, which provided that peacekeepers of non-party states over acts and or omissions related to United Nations operations were exempted from ICC jurisdiction. Those resolutions perfectly illustrate how the Security Council can misuse its powers under the United Nations Charter to unjustifiably impose a personal limitation upon the ICC. Taken together, with a deferral, the Security Council creates a temporary asymmetry in the enforcement of the Rome Statute by exercising structural power, because the Council can prevent the legitimate exercise of ICC jurisdiction over nationals of some states, while others remain subject to the jurisdiction of the ICC. However, With a view to the drafting history of this provision, it is also important to note that the strong mistrust of the Security Council by many states has also resulted in a number of safeguards which limit the structural power of the Council in regard to this provision. In this sense, the requirement of collective action and the limitation of the deferral power in temporal terms are counterforces that, to a certain extent, water down the claim of legal neocolonialism in the context of Article 16. The second scenario that was assessed relates to the rejected application to defer ICC proceedings against the Sudanese President al-Bashir and the President and Deputy President of Kenya, Kenyatta and Ruto. In this context, the question arises whether a non-deferral of ICC proceedings in these situations also constitutes a case of legal neocolonialism. Many states have contended that Article 16 was contemplated precisely for situations such as those in the Sudan and Kenya. However, we know that the Council repeatedly rejected African Union demands to make use of its deferral powers in these situations because the Security Council member states were not able to find a consensus. In this regard, it is also irrelevant that the majority of states, represented by the non-aligned movements, the Islamic Conference and the League of Arab States, would have favored a deferral. With regard to both situations, thus, the Security Council has exercised structural power firstly, in that it actively refused to make use of Article 16, and secondly, in that the minority opinion of a few members of the Security Council has defeated the opinion of a majority of non-member states to the ICC, to the Security Council. However, the mere fact that structural power is exercised does not also automatically imply that the exercise of structural power reflects a case of legal neocolonialism. Rather, the previously elaborated framework of neocolonialism requires that the exercise of structural power results in asymmetry in the enforcement of the Rome Statute. In the cases of al-Bashir, Kenyatta and Ruto, however, the exercise of structural power did not trigger an asymmetry vis-à-vis nationals of other states which are subject to the court's jurisdiction. In other words, the non-application of Article 16 does not serve the production of traditional inequalities in the enforcement of the Rome Statute between states possessing inherited structural powers and states that do not. Rather, as we saw in the context of Resolutions 1422 and 1487, it is exactly the ill-founded application of Article 16 which allows the Council to establish unjustified immunity exemptions from ICC prosecutions for states possessing inherited power. I will now turn to the last object of investigation, notably United States bilateral non-surrender agreements, which were assessed in light of Article 98, paragraph 2. This provision requires the court not to proceed a request to surrender in case the requested state is confronted with an obligation under international law, with a conflicting obligation under international law. It was only shortly after the entry into force of the Rome Statute that the United States actively sought to conclude bilateral non-surrender agreements to prevent surrender of United States nationals to the ICC, with both states parties and non-states parties to the Rome Statute. This they did by exercising pressure on states, parties and non-parties alike, threatening to cut military assistance in case of non-ratification. It remains to observe that the this did not hold true for allied nations. I will come to this. As a legal basis, the United States enacted the American Servicemembers Protection Act, which you may also know as the Hague Innovation Act, which envisages that non-compliant states are sanctioned accordingly. As I said, NATO states and other important allied were excluded from this provision. Compared to traditional status of forces agreement or extradition obligations, these bilateral non-surrender agreements are atypical in that they neither allocate jurisdictional competences between states nor contain an obligation of the third state to extradite suspects to the United States. While the United States consider these agreements as valid international agreements under Article 98, two particular issues raise doubt about their conformity with this provision. On the one hand, these agreements typically extend to all nationals of the United States and are thus not in line with the personal limitation of Article 98, which refers to the concept of sending state. On the other hand, they do not contain an obligation of the contracting parties to prosecute perpetrators of international crime subject to the Rome Statute. Rather, they merely encourage states to prosecute where appropriate. The most problematic situation in the context of these agreements is when states parties have concluded such agreements after they have ratified the Rome Statute. In this case, the ICC is not prevented from proceeding with a request for surrender on the basis of Article 98, paragraph 2, because the states parties, with the conclusion of such bilateral non-surrender agreements, have acted in a manner which runs counter the object and purpose of the statute. However, even though these agreements are not covered by this provision, it is likely that the contracting states parties will give precedence to these bilateral agreements over an ICC request. Thereby, it is important to note that even when a new agreement between the United States and a state party to the ICC is not covered by this provision for the aforementioned reason, it is nevertheless a valid agreement which is binding on the contracting states. As non-compliant states may be sanctioned accordingly, it is likely that the United States bilateral non-surrender agreements are given priority over ICC requests to surrender. In this case, United States nationals who commit crime on the territory of a state party to the Rome Statute retain immunity from ICC prosecution because a request for surrender by the ICC is unjustifiably not complied with by the state party, despite the fact that the underlying bilateral agreement does not warrant the application of Article 98, paragraph 2. As compared to nationals of other non-party states, this effectuates an asymmetry because these nationals remain potential targets of ICC prosecution on the basis of Article 12(2)(a). The question remains whether the asymmetries identified are an example of legal neocolonialism. The answer to this question, in my view, is no. The reason for this conclusion is based on the previously explained distinction between relational power and power emanating from structural conditions in the context of the ICC. I have noted previously that the United States has pressured states into such agreements by threatening to cut military assistance, notably of smaller states. In other words, the agreements are a result of the relational power exercised by the United States against states dependent from them for military or other reasons. By contrast, states parties which have resisted the relational power exercised by the United States had to bear the consequences in form of withdrawal of military assistance. As I have explained beforehand, relational power, as opposed to structural power, is power exercised in a temporarily limited relationship between two or more unequal actors. In the context of bilateral non-surrender agreements, this non-permanent character is exemplified by the fact that some states have signed these agreements but subsequently refused to ratify them. In this sense, the asymmetries and immunities produced are not necessarily permanent and can be subject to change, a feature that is not observable with regard to systemic inequalities based on structural conditions. Within the scope of the present study, accordingly, the conclusion of bilateral non-surrender agreements and the resulting asymmetries in the enforcement of the law of the Rome Statute may not be labeled a case of legal neo-colonialism, because the power exercised is not related to structural conditions that promote a typical neo-colonial outcome. So that was the presentation. Thanks a lot.
Thank you very much.